Welcome to the Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Michael Baranowski, a political scientist at Northern Kentucky University. With me today is my regular co-host, Cleveland area attorney and Republican factotum Jay Carson, but joining us today for this special, our first ever three-person episode focused on the retirement of Supreme Court Justice Anthony Kennedy is Northern Kentucky University law professor Ken Katkin. Hey, guys.
Good morning.
So I thought we could start by talking a little bit about who Anthony Kennedy was, as a judge, because obviously he mainly sided with the court's conservatives. In fact, in every major 5-4 decision this term, I believe he did, but he would sometimes provide a pretty important swing vote for the court's liberals, at least in the past. So what do you think differentiated him from Thomas, Alito, Gorsuch, and Roberts? Why don't we start with you, Ken? What do you think?
Well, he you could answer that question from a lot of perspectives, but I think from a perspective of his approach to being a judge, I think he really liked being the swing judge. He really liked being the center of power on the court. He really liked it that all the arguments were directed to get his vote. And I think that was a big motivating factor for him. And so that actually required him to vote sometimes with the liberals, right? Because the whole thing of being the swing judge and the one who gets to decide all the cases is that your vote can't be reliably counted on by the faction that you're in his case, the conservative faction. And I think he did fancy himself a libertarian. His libertarianism influenced his judicial philosophy. He was sympathetic to some kinds of individual rights claims, whether it was in gay rights cases or death penalty cases, or the cases with the Guantanamo detainees that the other conservatives were not sympathetic to. So I'd say that's the main thread. But he did share some of the agenda and obsessions, I would say, of the other conservative justices, particularly in areas like states' rights, which he would call federalism. He was a very reliable vote in those kind of cases. So I'd say that's what I would say would be the broad strokes of his approach to his role on the Supreme Court.
Yeah, and Jay, now coming at it from the right, I know a lot of folks on the right were sometimes driven crazy by Justice Kennedy at times, and I bet a few times you were one of those people. So, what is it about Kennedy that maybe made people on the right kind of very conflicted about him?
Well, I think first, this is just a funny historical note that people maybe forget. But Justice Kennedy was appointed. He was really sort of the second choice. The first choice being Robert Bork, who invented the verb, borked for what happened to him. And Kennedy was then appointed later as someone who was seen rightfully so as more moderate. I think Ken's right as far as describing where Kennedy comes from. He was he was pretty doctrinaire on your typical statutory interpretation, conservative view of economic rights. Where he differed was on this expansion of, for lack of a better word, call it a substantive due process in sort of the social sphere. And that has always troubled conservatives for a number of reasons. One, it's difficult to find, at least for me to find, in a lot of Kennedy's opinions, particularly the same-sex marriage case last year. What's the articulable principle that he's talking about, and it does. I mean, it's troubling. And Ken said, "Look, he'd like to be the swing vote," and yeah, it's like Mel Brooks said, it's good to be the king. I think that's a little troubling that if he would do that without a guiding principle. I would prefer justices who you can say, look, this is pretty consistently we think where they're going to go, because there's a big value in predictability of the law. So I think that's what troubled me most about Kennedy was was oftentimes his decisions on these substantive due process issues didn't seem to be anchored to anything either in precedent or in natural law or something that you can really grab a hold of and say this is the Kennedy jurisprudence. It just seemed much more this is something I like, this is something I don't like.
See, my sense of it was always that he was more guided by kind of a libertarian ideology, and a lot of those decisions, especially the LGBTQ rights ones, are the ones I think about the most. That kind of desire to uphold the dignity of the individual and that sort of thing, and I felt like that was a thread that kind of ran through a lot of his jurisprudence. Is that? I mean, am I right there? Do you think, Ken?
Yeah, I mean that's the word I had used before. I do think he was a libertarian, but I think there were limits to how much he would infuse his judicial opinions with his own libertarianism, because he wanted to stay the swing vote even after he decided some of the landmark cases that we talked about. So, after he became probably the leading voice on the court for gay rights in a series of cases that started in the mid-90s and that ended in the same-sex marriage case, nonetheless, he wanted his vote to still be available in cases like the recent Masterpiece Cake Shop case, where people want to discriminate against gays. And so after being the justice who gave us same-sex marriage, he's also the justice who gave us the right of business corporations to discriminate against gays. After he was the justice who saved Roe versus Wade in some important cases in the 90s, in the last 20 years, he's very rarely seen a restriction on abortion that he wasn't willing to approve and sustain. So he'll make libertarian pronouncements, but I think, I really do think his highest priority was to be the king, the swing vote, the center of the court, and that transcended his libertarianism, and that made him very much willing to weaken the kind of libertarian protections that he would announce in the major cases.
Well, that's really interesting that you guys, I mean, for all your political differences, seem to agree that it wasn't. I mean, to a certain extent, while political philosophy and judicial philosophy may have guided Kennedy, this sort of, I guess you could call it, for lack of a better word, ego, maybe made him a little less consistent to his political or judicial philosophy, just to be the king there, which I think we can agree is not necessarily a great quality in any judge, but especially in a justice on the Supreme Court. One thing, I'm sure you guys have noticed this too, is that in all the coverage of this, and of course there's been a ton, I've gotten a sense that the court oftentimes seems to be portrayed as, just another political branch. The justices just kind of being politicians in robes, always looking basically for any sort of a feasible rationale to advance whatever their ideological agenda happens to be, and so we get a lot about political ideology of the justices, but I feel like we don't hear much at all, at least in the mainstream media, about judicial philosophy. And I'm wondering if you agree with me on this, and if you do, if you think that's problematic, or it's maybe giving people a false or skewed impression of the court. Jay, what do you think?
Well, from my perspective, and again, this is taking, I'm looking at this from an originalist, textualist kind of perspective. Yeah, absolutely. I think that's the case. And I think that the media is at fault for sort of, one, simplifying this as to, it's a Republican versus Democrat. The other piece, and I think Ken will disagree with me on this, is that I think if the media were to try to accurately portray judicial philosophy, I think it would not necessarily go well with the members of the court who are more to the left, simply because there's the idea of a conservative judicial approach is we're going to treat words. It says what it means. Every word has some sort of meaning. We're going to look at what was the intent, to the extent that it is necessary to look at the intent of when this clause was placed in the Constitution or this statutory provision, and we're going to look at history and precedent and give those really some pretty heavy weight. Whereas and Ken can speak to this better than I can, but the other philosophy is, though this is a living, breathing Constitution. I guess it could be, down to Scalia, who said the Constitution is dead, dead, dead. And what you have is what you get, and you can extrapolate those basic principles to new situations that come up, but it's not an evolving document with new rights that are created through the judiciary or as they would put it, found, emanating in penumbras and so forth. I think that's the big difference. And to me, I think one is intellectually and superior to the other, but I expect Ken will disagree. So.
Ken?
Yeah, I mean, actually, I think I'll disagree with all parts of what Jay said, although he expected me only to disagree with half of it, I think. So, I would look at the courts probably the same as the other branches of government, where let's take something like the Justice Department, right? If you look at what your typical assistant U.S. attorney is doing in a typical case, I'd say that's fairly non-ideological, non-political work. If you have an ordinary criminal case, it's not going to matter that much whether the prosecutor who's assigned to that case is a Democrat or a Republican. There's not going to be opportunities for that to come out. But as you move up to the heads of departments, as you move up to the level of the Attorney General, it matters tremendously, right? We're seeing huge policy shifts because Jeff Sessions is Attorney General. He's doing a lot of things differently than how Eric Holder or Loretta Lynch did them. And you would expect that because that's a political appointment. That's part of the president's cabinet. Now, I would say it's identical in the courts. I think the lower courts, the federal district courts, to some extent the federal circuit courts, a large part of the work that they do, it would not matter that much whether the judge in a particular case is a Democrat or Republican. In fact, the circuit courts, the U.S. Courts of Appeals, sit in 3-judge panels, and very frequently a 3-judge panel is going to include both Democratic and Republican appointed judges, and almost all of these panel decisions are unanimous. You rarely see dissents, except in the most hot-button cases. But when you get up to the level of the Supreme Court, I think the public is basically right to look at it as being politicians in robes. I think it's absurd to talk about the kind of originalism and textualism that Jay was just talking about as anything other than the Republican Party platform. When you hear the word originalism, you're talking about a justice who's saying, I am going to implement the Republican Party platform always. And when they talk about the original, the history, the precedents, things like that, they're always imagining kind of the Leave It to Beaver time of the 1950s. It's got never anything to do with the 1780s or the 1860s. And so I think that is when people use those words, those are code words for saying I'm all about the Republican Party platform.
Well, what about this idea?
I would say John Roberts would. If you take a look at the Roberts vote on Obamacare, though, that certainly he took what I think would be described as a judicially conservative position, in that we're deferring to the legislature.
He didn't. That's just wrong. The Obamacare decision was an incredibly conservative judicial activist decision that struck down everything that was important in the Affordable Care Act and tried to position itself as this is the Roberts opinion I'm talking about, that tried to position itself the way that you described it. But the Medicaid expansion was substantially more important than the individual mandate. And he did strike it down, and there was no basis in text or history or precedents for striking down any part of that law.
Well, I think almost everyone would agree that the person that Donald Trump is going to nominate to replace Anthony Kennedy is going to be to the right of Anthony Kennedy. And that it's likely this is going to happen almost certainly before the court's next term starts in October. And, there are some people who say that, Mitch McConnell used this pretext to not hold hearings on Merrick Garland, who, of course, was President Obama's nominee to replace Scalia, and that therefore, by the same token, we should allow the democratic process to work its way through and wait until after the elections to basically allow the public to have its say as to what sort of a Senate they want to advise and consent on this nomination. I was wondering what you thought about that, Ken?
I think it's I think the Democrats should oppose the nominee. I don't know that they're going to succeed in stopping anybody. The reasons for opposing it seem to me to have to do more with if they're going to run an election on the idea that they're going to provide a check against Trump, they need to work on actually providing a check against Trump. They can't just say, our whole thing is that we're going to provide a check against Trump, and then when something big comes along, say, well, we're not going to do anything. So I think they have to position themselves against it. I don't really see a good way to stop it unless Trump does something, which I don't think he will do. If he appoints the kind of really low caliber people that he has appointed to his cabinet, there may be an opportunity to swing a few Republican senatorial votes based on the sort of credentials of the nominee. But I don't think he's going to do it. I think he's going to stick with that the Federalist Society list that he chose Gorsuch from, and some are saying that he's even made a tacit deal with Kennedy that he will nominate a former Kennedy clerk, which actually Gorsuch also was. And if he does that, I don't see any Republicans voting against this nomination.
Yeah. Jay?
At first I'd say, I think that the differential, and again, I expect argument on this point, but one is there was a vacancy that occurred in the midst of a presidential election. And this is occurring in the midterms before a. There's always an election. It's at some point. So, you can disagree with what McConnell did. If you want to say it's somehow a dirty pool, not to have held hearings. And if you remember, I was on record saying he should have held hearings.
Yep.
But he was certainly within his constitutional rights and rights under the Senate rules not to. And I think the argument that, look, we're in the midst of a presidential election, and the president ought to get a nominee who he or she wants. And I think that's a let's put it this way. That's not a frivolous argument. And there was also really a pretty big element of risk for McConnell in doing that, and the idea that look, Merrick Garland was seen as sort of a centrist, and the idea of if Hillary Clinton had been elected, she could have appointed someone much farther to the left. So. Look, it's. I think someone has said all procedural arguments are hypocritical, and to some extent this falls in there. But I would agree with Ken that I think there's going to be the Republican votes to do this. I have to think for all of Trump's sort of fly-by-night operations and announcing policies and just jumping into stuff. I have to think this is a situation that was foreseen for some years, right? So you've had some very smart people thinking about this, before Trump even announced that he would be running. So my expectation, again, with the input from the Heritage Foundation, Federalist Society, this is going to be a pretty strong list of folks, and it sounds as if they are reaching out to the senators who need to be reached out to sort of smooth this process. So
yeah. Well, I will say before we move on the McConnell thing, of course, what he did with Garland was ridiculous, was a ridiculous pretext and unconscionable, and I find him just sort of a reprehensible person for saying that he is all for these norms of the Senate and all that. But Mitch McConnell's interested in power, and that's really it. And so, in some ways, I find him worse than your Ted Cruz's and so forth, who at least are who they are. But that's another matter. I have my issues with Mitch McConnell. But
actually, Michael, can I add one more thing before we move on?
Do.
Yeah. So first of all, I know Jay had mentioned Judge Bork earlier. Nothing unfair happened to Judge Bork. He was given a hearing and he was given an up or down vote. He wasn't filibustered. He wasn't denied a hearing. And in fact, there were enough Republicans on the court that if they would have voted for him, they could have confirmed him without any Democratic votes. But what happened was that after he had a fair hearing and the Republicans were in the majority, and they took an up or down vote, he only got 48 votes because some of the Republicans defected. So I can't see that that's at all comparable to anything that happened to Merrick Garland being denied a hearing.
Well, again, I would say that I'm not saying anything unfair happened to Bork, but that was really probably the first time in our history where uh, objections were lodged on an ideological basis. The history before had largely been that a president got his nominee. There were pushbacks here and there, and it was as long as the nominee was someone who had the credentials, which I think Bork did. Decisions weren't based on ideology, and that was really the first time that happened.
Oh, that's completely wrong again, and that really proves my earlier point about Republicans talking about originalism and looking only back to the 1950s. Because it's true that in the 20th century there were 13 times that Republican presidents were able to get their nominees confirmed by Democratic Senates without regard to ideology. That never happened even once in the other direction. There's no 20th century examples of a Democratic president getting their nominees confirmed by a Republican Senate. Literally never happened. So that's a one-way 20th century norm. And if you go back to the 19th century,
Ken, what about the Clinton years?
What about the Clinton years? They had a Democratic Senate.
So Ken, what you're saying is that in instances, let me just be clear, in instances where there was a Democratic president and a Republican majority in the Senate, we can't find any instance in the 20th century.
Not once in the 20th century.
But we could find it the other way. Gotcha.
13 times the other way. And also this idea about ideology not coming into play, if you go back to the John Tyler administration in the 19th century, the Senate blocked 5 John Tyler nominees because they didn't like John Tyler. So there are precedents for that go to presidential politics, but the originalism for Republicans always stops at the 1950s.
Well, let's move on to a few issues, because obviously people are talking about a lot of things that might be very different on a court, assuming, and I think it's a fair assumption, that President Trump's nominee is going to be kind of along the lines of a Gorsuch type person, and that person is going to be confirmed and be sitting for the term that starts in October. So let's start with partisan gerrymandering, which recently came before the court, and it seemed to me that even though Kennedy sided with conservatives this time, in the past, he's clearly expressed a belief that he'd at least be willing to consider a reasonable standard. So I'm wondering, do you think we can just basically forget about this now, and that we're not going to see the court rule on this, at least in the way that I think they should, that partisan gerrymandering is not constitutionally okay? Ken?
Yeah, I mean, this is one of these Justice Kennedy things. Justice Kennedy, because he liked, as we've talked about, to be such the kingmaker, he always held out the idea that he thought partisan gerrymandering could be unconstitutional, and if someone would just present him the right argument, he would rule against it. But he never did, right? So there never was a case where he ruled against partisan gerrymandering. I think given the likelihood that his successor will be to the right of him on that issue. I don't see the court striking down partisan gerrymanders anytime soon, but I will make this prediction. If they ever do it, it's going to be in the case where it's a state where the Democrats did a partisan gerrymander.
Jay, what do you think?
I would say the originalist 1950s approach, as Ken likes to put it, would be that no one has ever found a right to have a district configured specifically based on political preference. It's been a political question since the founding, and I think I would expect the Trump nominee would view it that way, that this is a political question, and there's no particular right to have your state configured in a way that suits someone in a particular district.
And just to be clear for listeners who aren't aware of that idea of political question, people might hear that and say, well, aren't all these questions political questions? And so when you could maybe explain just a little bit about what you mean by that, because of course the court will sometimes say that it won't rule on what they call political questions. So what does that term mean more kind of specifically in the context of the court?
In the context of the court, it means that this is a decision that is to be left up to another branch. that this is for example, the one big case that's typically cited for political questions had to do with a seating of a House member. I believe a House member, or was he a Senate member? Ken, you may.
Well, Adam Clayton, if you're talking about Adam Clayton Powell,
yeah.
He was a House member, but the court actually rejected the argument that was a political question and ordered that he be seated.
Right. But I'm saying that's the typical type of political question issue that you come up with, where you've got a situation where a power is assigned to a political branch of government, and the court says, we're not going to wade into this. This is up to someone else.
Yeah, I mean, usually in the way the court has articulated the political question doctrine, it has to be that you have a trial-like procedure that's the Constitution delegates to one of the other branches of the United States government. So that could have nothing to do with redistricting or gerrymandering, because the other branches of the United States government don't play a role in districting. But you do see it in cases like the most famous modern cases about this, where the court finds that a case can't be decided by courts because of the political question doctrine, would be things like whether there can be an appeal from an impeachment. Right, so there have been some federal judges who've been impeached and removed, and they tried to take appeals into the courts. And the Supreme Court says, well, because the trial of impeachments is delegated by the Constitution to the Senate and takes place in the Senate, which is one of the other branches of the United States government, it's not appealable into the courts. So there's really I don't think there's any serious application of that doctrine to gerrymandering or redistricting, but it's a doctrine about allocation of power within the United States government, between the three branches of the United States government.
I'd also like to talk about LGBTQ rights. Now, this is a big area where Justice Kennedy often sided with the court's liberals. And of course, he wrote the majority opinion in a number of very important cases involving these rights. And so I'm wondering how you think his legacy is going to stand up here. Particularly, there are people wondering, well, will a new court potentially overrule its fairly recent decision on same-sex marriage? What do you think, Ken?
That's a tough one. I think here's what I think about that, which makes it hard to predict. I think that Chief Justice Roberts, from an institutional standpoint, would not like for the court to be seen as being so nakedly political as that. He usually tries to, from an institutional standpoint, have the changes in direction be more incremental and modest, and that would be very sudden and very, would be perceived by most people, I think, as sort of purely based on the change in personnel on the court. The problem is Roberts may not be able to stop a case like that from coming up, because it takes only 4 votes, not 5, to grant certiorari and put a case in front of the court. And I think he may be the only one of what will be the new conservative bloc with that kind of concern for institutional norms and for the perception of the institution. And I do think if they bring the case up and they put it in front of him, and he actually has to cast a vote, I think he would repeat his vote, Obergefell, against same-sex marriage, and so that would be a 5th vote against it.
Jay?
I think that's what makes it hard to predict. I think the chief would like to avoid that case, but it might have to vote that way if it came up.
Gotcha.
Yeah, I don't think it's going to happen. I think Roberts would prevail on the other justices, and I think there is an interest in seeing stability in the court, and the idea of sort of a whipsaw effect of, okay, we're ruling this year and overruling it 2 years later. I think that would be a big problem. So no, I don't. I mean, I agree with Ken. Look, there's something could happen, but the other thing to remember is you'd have to have some sort of statute to come up there. I think we're at a point in this country where I think that would be a tough sell. I don't see it happening from a political standpoint that some state says, okay, we're going to ban gay marriages, and that case goes up.
Okay.
Well, they might not need a new statute. A lot of them have statutes like that on the books, and all they'd need to do is just refuse to give gay people the marriage licenses under under the statutes that are already on the books in the states.
Yeah, but outside of a Roy Moore type situation, I just don't see that happening.
Okay. Well, what about what about this? I mean, something that's not quite as not dramatic. I don't know, but denial of services to same-sex weddings. I mean, we saw that, in the Masterpiece Cake Shop case, for instance, and I believe the court ordered a case involving a florist who denied service to a same-sex wedding back down to be tried. So how do you see this one shaking out? Because my take on the Masterpiece Cake Shop, at least, was it seemed like Kennedy said, well, if there hadn't been these comments by this regulatory or this judicial type board, essentially, that really kind of was his big problem with it. And so do you see the new conservative majority basically saying that, hey, if you are an artist in service of a same-sex wedding, which I guess would cover not just cake makers, but florists and probably photographers, videographers, all that kind of stuff, do you think that this is going to be more of a thing now? Sorry.
I'll start. In terms of the things like where there is some sort of artistic presentation that goes into it that can be construed as speech endorsing a same-sex union, yes, I think so, and I think the court will at some point draw a line, much like what the concurrence did in Masterpiece, is sort of drawing a line between refusal of service based on your sexual identity versus requiring speech in support of that. So, I think you're going to have the situations where, as in Masterpiece Cake, the record showed that, and the owner had said, look, if you want to buy cupcakes, if someone wants to buy a cake off the shelf, he's not going to discriminate based on sexual orientation. But is not going to participate in a ceremony that he feels violates his religious beliefs.
Well, and I wonder how far you could take that, though, because like I said, I could see that argument applying to, say, florists and photographers. But, caterers, they make food and do, you could argue that, cooking's an artistic thing. I mean, I could see this potentially being stretched to a degree where I would certainly be uncomfortable with. Ken, what do you think?
Yeah, I think that's where they're headed for sure. I mean, even in the Masterpiece Cake Shop case, you noted the Justice Kennedy's opinion for the court focused a lot on sort of certain supposed comments by members of a state commission in Colorado, and didn't focus on the kind of First Amendment free speech type argument that you're talking about now. And of course, the reason for that is that the facts of that case were that this gay couple just simply wanted to buy a cake off the shelf. They did not at all try to have the cake maker make any particular customized cake that reflected the same-sex marriage. But because you have some ideological conservatives who are on the court who are just hell-bent to vote in favor of the baker and against the gay couple, some of them were just willing to overlook the actual facts or rewrite the actual facts. And Kennedy didn't go quite that far, so he rested on some thinner legal justifications. But I think that's going to be the ideological bent of the court. If they can't overrule the same-sex marriage case, they're going to do everything they can to create open season for anti-gay discrimination in the country.
Yeah, and that was sort of that's
on the agenda, Ken. Open season for gay discrimination. That is I'm sorry, I got to push back a little bit.
Well, let me say this.
Masterpiece Cake Shop.
My sense of things, and we're going to get to this in just a minute, but before we do get to Roe v. Wade, my sense of things is in the wake of Roe v. Wade, when we had started to have a more conservative court, while they didn't overrule it, certainly it was, I think it's undeniable that it was basically been chipped away at. And my thinking is that with a more conservative court, we're likely to see this same sort of thing when it comes to LGBTQ rights. So, maybe gay marriage itself won't be overruled, but there'll be various other types of things that the court will say are okay because of this is compelled speech or this is a religious sort of thing. And that's my concern and honestly my fear about this. Ken, what do you think? And then Jay, you can comment on that.
Yeah. Well, I think that's right. I mean, one of the things about Justice Kennedy is in his famous opinion in Planned Parenthood versus Casey, which is the 1992 decision where a lot of liberals give him credit for having saved Roe versus Wade, giving the fifth vote to save it. That same opinion created a new constitutional standard that had never existed in constitutional law before, called the undue burden standard. And so Kennedy says, on the one hand, there's a constitutional right to reproductive choice, which includes the right to choose abortion. But then he says, on the other hand, unlike any other constitutional right, state governments are allowed to do everything they can to persuade people not to exercise this constitutional right, to take the position that it's a bad constitutional right, that people are being bad when they exercise it, and to try to talk them out of it. And based on that doctrine, which Kennedy created more or less out of whole cloth, there's been very few cases, really only one or two abortion restrictions in all the years since 1992, where the court has struck down those restrictions as violating the undue burden standard. And the standard overwhelmingly protects state restrictions on abortion. And there's a lot of parts of the country now where there's no abortion services available because these state restrictions have made it more or less impossible to provide it. So I think that's the model, and I think that will continue.
Well, let me before you get to your response, what I'm thinking about it, and maybe this sounds paranoid and crazy on my part, and if it does, I don't know, but I'm visualizing kind of that model for LGBTQ rights, saying that there is this these equal protection concerns and all that, but let's say that you can't disallow same-sex marriages, but you can require couples who want to have a same-sex marriage to seek some sort of psychological counseling or something like that. And I know that sounds weird and perverse, and in my head that just seems so unlikely, but then I think there are people who firmly believe that this is just such a twisted and wrong thing, and maybe in some states they have a majority, and I can see that being a big campaign issue and so forth. And I don't know, am I crazy to think that this is a possibility? Jay, why don't you go first, and then Ken, you can respond to that.
Yeah, you're crazy.
Okay.
I think we're not at that place with our country at this point. I don't see any something like those kind of restrictions being saleable anywhere. Because first of all, I think that brings in a whole lot of issues beyond same-sex marriage that I think would violate substantive due process. So I just don't see that happening. And I'm trying to imagine the scenario other than sort of the denial of services, where there would be this chipping away. And I'm not seeing it. I think there are going to be a bunch of cases of okay, what's speech, what's just providing a service. And again, we haven't even gotten to that point where the court will draws that line, saying this is you can't compel speech, but you can't deny service. But I think that's where it's going. Your example for the caterers, I think that's the kind of case that it'll go through the court and they'll figure it out. My sense is that someone like a caterer wouldn't be speech, but maybe there's a better case to be made. So no, I just don't. I don't sense this animus in the country to discriminate against LG people. So I don't think there's going to be a case to take up on those grounds. I think there may be, as we said, some First Amendment type cases, about where you draw that line. But I don't see new statutory restrictions or a state trying to revive some old statutory prescription.
Ken, what do you think? Do you agree with Jay that I'm being paranoid about this or something?
Well, I would probably go in between. I think I'm somewhere in between where the two of you are on this. I sort of agree with Jay that there won't be the type states aren't going to. I don't predict that they're going to enact the type of statute that you described. So I don't think those kind of cases are going to come before the court. But what I do think is that with the a combination of very aggressive free speech doctrines that go to things that don't have much to do with speech, very aggressive religion doctrines, particularly under the Religious Freedom Restoration Act, as well as under the Constitution, where you could basically characterize any kind of anti-gay bigotry as a right of religious exercise or religious expression, and with a willingness of some justices on the court to twist facts when necessary in cases. I do think that when it's not only going to be provision of service discrimination, like in Masterpiece Cake Shop, but also employment discrimination, landlord-tenant discrimination, various kinds of anti-gay discrimination, I think the court is going to consistently approve and endorse those kinds of discrimination, so that we're going to have a situation not where states are passing the kind of laws that you're talking about, but where private people who want to discriminate against gays in a variety of ways are always going to be found to have some kind of legal right to do that.
Right. And obviously I saved this for last, but the one area I think that people are talking about most of all here with this new court is Roe versus Wade. I mean, right after, minutes after Kennedy announced his retirement, a CNN senior legal analyst, Jeffrey Toobin, he tweeted, "Anthony Kennedy is retiring. Abortion will be illegal in 20 states in 18 months."
16, Mike. 16. We're trying to speed it up, so it'll be, yeah.
So, Jay, obviously you think this is ridiculous. So you don't think that this is what's finally going to lead to Roe v. Wade being overruled?
No, I don't. And to some extent, Ken's right in that in a lot of ways it already has been overruled. The provision that Roe v. Wade created, where it was a trimester system, has given way to a viability line, and then it's also been given way to, in terms of what kind of restrictions states can impose restrictions, as so long as it's not an undue burden. I don't see that fundamental test changing. There might be some movement around the edges as far as what a new court considers an undue burden versus what Kennedy considered an undue burden. But I don't see a wholesale revisiting and saying we're overruling Roe versus Wade. One reason, again, I think is the authority of the court. I think Roberts would push hard against that. Secondly, whenever a court invalidates, overrules a prior ruling, part of the analysis is there a substantial reliance interest on this? And in this case, I'd have to say yes. For the past 45 years, there has been this reliance that there is a right to abortion in certain circumstances. It's not an unlimited right, but I think that the court's integrity, its authority would be they'd certainly lessen it. Were they to say no, we're just wiping all that out.
Ken, do you agree with that?
Yeah, I mean, I might have some semantic different ways of saying some of those ideas, but I basically agree with those ideas. I do believe Roe versus Wade functionally has already been overruled, because under the undue burden test, it's extremely unusual to find I think really the only thing that the court has ever said is an undue burden is a spousal notification provision, right? So Pennsylvania had a law that said if a married woman wants to get an abortion, her husband has to be notified, and the court found that was an undue burden. But there's nothing else the court's ever found was an undue burden. So
but Ken, there's a lot of cases that the court has declined to hear, where
right,
you've had circuit courts have found undue burdens.
But there's a lot of cases. Yeah, there's a lot of cases that the court has heard and has overruled pre-Casey precedents. So there were a lot of abortion cases between Roe in 1973 and Casey in 1992, where the Supreme Court struck down a lot of different kinds of restriction on abortion, and substantially all of those cases have been overruled under the undue burden test, so that the precise provisions that were unconstitutional between 1973 and 1992. These precise restrictions were later held to actually be constitutional. Many precedents were overruled. The other thing I would say is that this idea about when society gives substantial reliance on a Supreme Court doctrine, that they'll be more hesitant to overrule the doctrine. That is the precise language that was written by Justice Kennedy and joined by Justice Souter and Justice O'Connor in the 1992 Planned Parenthood versus Casey decision. But all three of those justices are now off the court. None of the other justices at that time signed on to that idea. Justice Scalia, in a dissent for the four conservatives in the same case, very vigorously and vehemently attacked that idea. And I think I don't see anybody but Roberts on the contemporary court really agreeing with that. And Roberts may be the swing vote on this issue, but what I think that means then is that Roe versus Wade may not be formally overruled by name. But I think the court will continue and even accelerate the idea that as it applies the undue burden standard, it will never, ever find that any restriction actually constitutes an undue burden, and thus every kind of state restriction on abortion will be sustained in the Supreme Court.
So neither of you,
but Ken, you would agree with me. No state could pass a across the board ban on abortion.
Yeah,
even the most conservative court. I mean, I don't see that happening, and I can't see how a court could say an absolute ban doesn't constitute an undue burden.
Well, let me ask you. Well, let me ask this, because I have this sort of scenario in mind. Let's say a state decides that whatever, as a matter of policy, that life begins at conception, and so they pass a law saying that in light of this, that the only grounds in which a woman can get an abortion is if her life is threatened, essentially. So it's not about viability or anything like that. That the fetus has an equal, or more or less an equal, sort of claim to protection as the mother does. I mean, is that something that the court could potentially look at and say, well, yeah, let's not even worry about viability. Let's just say that the only grounds under which a woman can get an abortion is if her actual life is threatened? Or is that just not something you see the court being willing to endorse? Ken? Sorry.
Well, I think that under the current precedents, including Casey and the undue burden standard, that would be seen as unconstitutional, because viability has to be taken account of under those precedents. But
right.
but I think where you're going with this is, would that be the vehicle to overrule Casey and Roe? I think if a state went that far, it's very hard to predict how it would go, because I think I would predict that certainly Alito and Gorsuch and Thomas would sustain a statute like that. And so, whether there's going to be a fourth and fifth vote to do that depends on who the new justice is, and depends on what Roberts would do if he had to be the deciding vote in that case, I think.
Yeah. Jay?
Again, I would say first, I don't know that the political will exists in any state for that kind of enactment. That said, even if it does, I think it gets struck down. I don't see any way. And I think the court as a whole is going to be reluctant to say we're going to completely revisit the undue burden test and throw the whole thing out and go back to, the states have an unlimited right to regulate an abortion. I think again, there may be some trimming here and there as to what's an undue burden and what's not. And Ken's right in that the strike zone for undue burdens is probably going to be pretty narrow. But I don't see that. I just don't see that kind of thing happening. And I think the court would put its credibility at risk if it did something like that.
Well, I'm thinking also, going back to Ken's statement earlier on about, the justices being very political. When I think about the sort of conservative backlash to Roe versus Wade and how it really energized sort of a conservative movement, I would think a lot of conservatives would say, well, no, the smart thing to do would actually be to overrule it in all but name. So that way we don't risk that kind of huge liberal backlash, essentially. So that would be the smart sort of strategic thing to do, is to not overrule it really, but to sort of limit it to the point where, constrain it to the point where it becomes more and more difficult for women to end their pregnancy. Would you agree with that, Ken?
Yeah, I mean, there's a theory that that's what all the prior Republican presidents were trying to do, because Reagan and George H.W. Bush and George W. Bush, each of them either succeeded in, or at least tried to, in W. Bush's case, to split their appointments to the court between pro-choice Republicans and pro-life Republicans. So Reagan put on O'Connor and Kennedy, who both became defenders of Roe. George H.W. Bush put on Souter, who became a defender of Roe. And George W. Bush actually tried to put on Harriet Miers, who was known to be pro-choice, but the conservative movement pushed back against that. So I think if you look at what Republican presidents have done and look at the disparity between that and what they've said, they've typically tried to put some Scalia type and Thomas type justices on the court to keep the loyalty of the right wing. But they've tried to prevent that faction from getting a majority, at least with respect to abortion. However, Trump's not thinking strategically like that, I'm sure. And I think there are easily 3 votes, and I'll repeat them again: Gorsuch, Alito, and Thomas, who would just simply overrule Roe in a second. They don't see any compunction about doing that. So it becomes the numbers game about is there going to be a 4th and a 5th vote for that? And the Trump nominee could provide one more vote for that, which would really leave that decision in the hands of Roberts.
Right. Jay, any thoughts on that?
I don't know. My sense is most presidents do try to seek some sort of balance on the court. I think there's always been this idea of, an unwillingness to make too sudden of a shift. So I think maybe there's something to that, but we'll see. And so often the other thing is, when presidents make these appointments, a lot of times you think what a justice will do, but they don't always do that. And I think you can. I think that was probably
Souter.
Yeah, a Souter is a prime example. Kennedy's another, where judges are truly independent, and you can't always predict exactly where they're going to go. So I don't know. I hesitate to think that there's a bigger thinking as far as I want to have this justice on there to keep the abortion debate alive so that I can get more contributions or something like that. But I think that's the functional thing of it. Yeah. And to me, it's if the fight moves back into the political realm, I think that's what most conservative minded folks on judicial issues would think is the right thing, right? That these issues be hashed out in state legislatures rather than by the court.
Right. Ken, you were going to.
Yeah. Well, the last thing Jay said, of course, means the overruling of Roe versus Wade. But I was going to say I don't think Souter was a surprise to George H.W. Bush. I think his pro-choice views were actually the reason he got the nomination, because I think Bush was looking to make sure that he didn't change the balance. He appointed Clarence Thomas, but then he appointed Souter, because if he would have appointed an anti-choice justice right then, the votes would have been there to overrule Roe versus Wade. And I think H.W. Bush just did not want that. Yeah.
Well, I would say on that I think that we are certainly in a very different world from the republicanism of George H.W. Bush. And I would almost expect that if President Trump, and this would shock the hell out of me, if he nominated someone who was even a little iffy on abortion rights, or someone who wasn't anti-choice, I think that actually the Senate, Republicans in the Senate, might push back pretty hard on that, because I think it's just a whole different world in terms of polarization on this issue. So I don't expect that anyone that Donald Trump nominates is going to be, by any stretch of the imagination, moderate. I don't think so. But we will see. He says that he will announce his nominee on, I believe it's July 9th. So we'll certainly be talking a lot about that. So again, I want to thank Jay. You, of course, you're here pretty much every week, Jay. So thank you anyway. But Ken, thanks so much for joining us on this. Like I said, I thought this would be. I was a little hesitant. Whenever you put two lawyers together, you never know what's going to happen. But there you go. I really appreciate your insights on this. So thanks everyone I hope you guys enjoyed the show. And before we go though, I want to thank everyone who's checked out my new interview podcast, Politics Plus. This week I talked to neuroscientist Tali Sherritt about the science of influence and how we can all be better influencers. A little sneak preview for next week. I'll be posting a conversation I had with Beck Dory Stein, who was a White House stenographer. Believe it or not, they still have White House stenographers for 4 years in both the Obama and Trump administrations. And she, as you can imagine, she has some pretty interesting stories to tell, and that'll come out next Monday. Of course, you can find Politics Plus and subscribe wherever you get podcasts or at the Politics Plus website, politicsplus.us. All right, well, that's it for this episode. Thanks, everyone, for listening. Listener support, of course, is what helps keep the show going. We really do appreciate it. So if you'd like to help us out, go to politicsguys.com/support. That's a direct link, or just go to politicsguys.com and you'll see the menu item there for support the show. Subscribing also really helps, as does sharing episodes, which you can do right in your podcast app. We would really appreciate that. Also, leaving reviews and ratings on iTunes helps out a lot. So if you want to get in touch with us, it's mail@politicsguys.com. There's our Facebook page where you can message us, and we post all kinds of stuff throughout the week. That's facebook.com/politicsguys page. And we are also on Twitter @politicsguys. The executive producers of the Politics Guys are Michael Baranowski, Jay Carson, Trey Orndorff, and Bruce Johnson. Today's show was produced by Michael Baranowski. We'll be back with the new show on Saturday. We hope you'll join us.